Welcome back. You're still watching The Globe. Somalia has concluded its submissions to the International Court of Justice by arguing that Kenya has repeatedly violated its territorial integrity. Lawyers acting for Somalia accuse Kenya of prospecting for oil in the disputed area and even digging a well north of the disputed border.
Somalia's lawyers also say that Kenya had admitted to licensing at least 5 oil companies to explore for oil in the disputed area. Somalia wants the licenses revoked and oil prospecting halted. The lawyers also added that while Somalia was entitled to massive reparations, it would not request these in the spirit of neighborliness. The court has given Kenya until the 22nd of March to file a written response. Kenya has refused to participate in the oral submissions. They accuse the ICJ of bias in the case, which concerns a 160,000 square kilometer triangle in the Indian Ocean.
Sadly, litigation can never resolve sensitive issues of security threats within the region. Kenya is confident of the strength of its case on the merits, namely that for over 30 years, Kenya has exercised uncontested jurisdiction in the maritime areas that Somalia now disputes.
The bench also rejected Kenya's request to address the council before the start of the hearings. Somalia also has until the 26th of March to respond to a question put forward by one of the judges on the subject of previous discussions with Kenya on territorial lines at the Indian Ocean. Somalia brought the case in 2014, saying that the maritime frontier should follow in the same direction as the land border, while Kenya argues that it has always been taken in a horizontal line from the point where the two countries meet at the coast.
Well, let's hear now from advocate and law lecturer in public international law, Evans Ogada, who's been keeping a close eye on this story. And he joins us now from Nairobi in Kenya. Thanks very much indeed for joining us. Welcome to the program.
Thank you very much.
So our viewers might be wondering, how is it that in 2020, 2021, that the issue of borders is still being discussed? One would have thought that Somalia and Kenya settled this decades ago.
Well, it's not unique to us that maritime borders specifically and borders generally remains a contention. We've had problems with borders. We had the Bakassi Peninsula between Nigeria and Cameroon that was adjudicated upon by the court only a few years back. We also have a couple of maritime border issues being adjudicated by the ICJ. The reason is this, that especially for coastal states, when the colonizing states departed, this was left to be dealt with under a special regime, which is the United Nations Convention on Law of the Sea that was brought into effect in 1982 in terms of its life, but ratified by states much later. So this legal regime is supposed to govern how coastal maritime disputes are resolved, and that is what the Somalis are arguing before the ICJ.
All right, so in theory, we know what the rules should apply, but I get a sense that these rules are not very clear, just given the fact that our coastlines are not contoured the same, and people might have different interpretations, and hence you have to go to court. How is it that Somalia and Kenya have different views about where the border lies?
Well, like you said, you correctly said, it's a question of interpretation, because the Kenyans argue that they have exercised de facto control over these particular territories. What they were arguing in their preliminary objection as acquiescence by the Somalis. The Somalis accepted Kenya's control over this disputed territory. Now, the Somalis want this to be adjudicated by the court using a formula that can be obtained from among others, the United Nations Convention on the Law of the Sea, and cartographic material that they attribute to Kenya and their own sources. So like you correctly say, it's not an easy thing. This has to be determined by the court. And that's why we have a dispute actively being settled in court now.
So what is Kenya's position? Because they've refused to go to the International Court of Justice for some reason. They've asked for delays. I believe they were granted 3 times already. What could be the issue for Kenya?
Well, honestly, I am a Kenyan, and I think we did not deal with this issue properly. We ought to have organized our housing and placed it in order. We have sought before 2 times adjournment of this case, and the court granted. We sought a 3rd adjournment, which was denied by the court. The irregularity of what we sought to do by a letter on the 21st of January was this. I thought it was weird for the Attorney General to try to address the court through a letter, yet we had counsels on record who ought to have addressed the court. Now that we have lawyers representing Kenya, those are the people to address the court, not the Attorney General addressing the court through letters. Secondly, I think we also were not organized for this, because we have been changing lawyers, and that is not good for memory and consistency in terms of dealing with the case. So Kenya will have itself to blame. Some of the reasons they are raising in the court is that the court is biased, and that they wanted the Somali national, Justice Abdul Kawi, to recuse himself. I think these are not cogent reasons, for the reason that under Article 31 of the Statute of the International Court of Justice, Kenya had the opportunity, and indeed used it, to appoint an ad hoc judge. An ad hoc judge meaning a judge for this particular specific case. We had a Frenchman, Gilbert Guillaume, who came in as a judge for Kenya. So, and even in the manner that the court makes the decisions, the court votes, and the Somali national is only one person amongst these many judges. So the fears of bias and all these allegations Kenya is raising, including demanding that they had to physically attend the meeting, only make us look bad. We were not organized.
I suppose as well, look, if you've got the UN conventions on how to decide these issues, that representations that each country makes doesn't sway too much, because the judges will sit there, I'm guessing, and they'll say, which formula do we apply in this instance? Is it the equidistance? Is it the other lines that they use? And then they make a decision based on what they think is fair. What kind of representations can countries make to alter their decision? Because I'm thinking that, you know, these judges look at the law, apply it as best they can, and that's it.
Well, ideally, any serious nation, and I had hoped that Kenya would have been serious, should have seen the profit of this not going to the court at all. We ought to have taken the path of diplomatic negotiation, or which Kenya squandered when we had the opportunity to come to an agreement without this being a contentious court matter to take to the court. We will have agreed and used whatever formula and narrowed the issues. Our failure is a failure of diplomacy. Diplomacy will have resulted into a back and forth, and we'll have used other means like arbitration, conciliation, whichever means that will have been more profitable as opposed to going to court for a litigation matter.
And I suppose at the heart of this issue is the oil and gas that's happening offshore at the moment, isn't it?
Yes, the geopolitical tectonics that are being argued. We've had, for example, the Turkish government having this close relationship with the Somali administration. We have big boys, big powers, having a lot of interest in Somalia in terms of and not only the oil and gas, but also in terms of security. And security is also a concern for Kenya because we have the Al-Shabaab menace closer to home on that particular part of our frontier. So yes, we have economic reasons and security reasons to be concerned about that part of the country.
So there are these accusations of wells being drilled and agreements being signed in an environment where there is doubt and questions. What happens to these contracts and these agreements?
Well, depending on how this is decided, that the future or the legality of these contracts will be hinged on the decision of the court. Because, for example, if Kenya granted concessions to particular companies or particular state interests, and the decision goes against Kenya, those concessions, those contracts become a nullity. We will have no jurisdictional claims to those parts that will have been ceded away to Somalia by operation of the court decision should the decision go against Kenya. And vice versa with the Somali. If the Somalis lose and the decision is decided in Kenya's favor, then the concessions, the contracts become valid and they can continue as normal.
All right, so let's get to what's probably going to happen in the coming weeks. The ICJ have said that they're going to carry on with this case, with or without Kenya, and they're going to use the documents they've already submitted. Once the ICJ decides, is that it? I mean, does it become a question of each country can now enforce their borders as they please?
Well, you have to understand that the ICJ is a creation of international treaty. And when you sign on international treaty, under international law, there's the principle of pacta sunt servanda. You are obligated to respect treaty obligations in good faith. So whichever country has the decision decided against, it will have to abide by the decision of the court. And this matter being decided without the presence of Kenya is not an aberration. We had the United States in the Nicaragua case, the paramilitary case, where the United States decided to walk away from an active litigation in court. And indeed, the ICJ proceeded to pronounce against the United States. And to embarrass the United States, Nicaragua sought to enforce the decision of the court through the mechanisms of the United Nations Security Council. And this might be the path that Kenya might have to walk should this decision be decided against it. It will not only be binding pacta sunt servanda, but the mechanisms of the United Nations Security Council might be employed to enforce the decision against it.
All right, very tricky situation for both countries. Diplomacy between the two is at an all-time low. So a resolution, one way or the other, is probably quite urgent at this stage.
Yes. We still have a narrow activate meaningful and robust diplomatic efforts. That will mean that if diplomatic efforts bear fruit, then Somalia might be convinced to withdraw its application and give diplomacy a chance. As of now, the court will continue and make a determination on this issue, whether Kenya is involved or not.